Hello, and welcome to another edition of Law and Democracy, a podcast of the election law program at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law Program. And I'm really delighted today that in addition to having Tony Goggin, a Senior Fellow of the Election Law Program at Ohio State, with us, we also have, returning to our team here, Daniel Tokaji, who is currently the Dean at the University of Wisconsin College of Law, having been there for 5 years now. But prior to that, had been our colleague at Ohio State and a significant contributor to the election law program here. Dan, it's great to see you again and to have a chance to chat a little bit about some of the issues in the general area of election law and democratic process. Welcome.
Thanks so much, Steve. It's wonderful to be here and especially delightful to be talking to old friends.
Dan has just recently published an article on racial voting that we hope to talk about. And he's also working in progress on some reflections on the 2024 election. Tony, I'll let you get us started here.
Sure, Steve. Dan, why don't we start with a retrospective on the 2024 election? What's your assessment of the quality of election administration in the 2024 election?
Well, thanks for asking that question, Tony, because, we in the world of election law, to us, it often feels like there's so much bad news all the time. And sure, in any election, there are things that go wrong. There are things to be upset about. There may be litigation outcomes that we disagree with. But to your question, my overall take on the health of our system of election administration is that it's quite good. I think if we look back over the past 25 years, the past quarter century, since the 2000 election and the Bush versus Gore decision, at a high level, I see enormous improvement, including the professionalization of the core of people, the dedicated core of people who run our elections. Remember Florida 2000 and the big mess that everybody saw that I think was, really kind of awful to see for people across the political spectrum. In my opinion, we've come a long way since then. And to me, the best evidence of that is what happened 5 years ago in the 2020 election, where, we managed this incredibly difficult transition for so many people from in-person voting at the polling place on election day to remote voting as a result of this global pandemic. And our election officials handled that magnificently, in my opinion. I also think that our system for resolving election disputes is on the whole pretty good. I've got some complaints. Chief among them is the Purcell Doctrine, or more properly, the hardening of the Purcell Doctrine, which I'm happy to talk about. But, I don't think it's a bad thing that we see more cases going to court, especially before an election takes place, than we did before 2000, right? My friend and co-author on our casebook, Rick Hassan, has meticulously tracked the rise in election litigation over the years before and since 2000 and found, not surprisingly to anyone, I'm sure, that it's increased. And further, that while there were fewer cases in 2024 than 2020, if you look at the 2023 to 2024 election cycle, that was the highest number that has been recorded. But I don't think that's necessarily a bad thing, because look, where there are disputes over what the rules are, how the rules should be interpreted, how they should be applied, we actually want courts to resolve those disputes. And they have increasingly in the years since 2024. And going again, since 2020, and going again back to the going back to the 2020 election, it's important to note that in that election, President Trump brought a lot of cases, President Trump or his allies, approximately 73 cases seeking to challenge the result of the election. All but two of them were rejected, and rejected by judges across the ideological spectrum, which to me is a good sign that our system is working. You've got to come up, you can't just make claims. You may be able to make them in the public domain, but in court, you've actually got to support them with evidence, which he and his allies failed to do in their claims of massive election fraud. The problem, of course, is that so many people don't believe, or at least didn't after 2020 believe, that we have a strong system. And that is a significant problem for our democracy, although it turns out that a lot of people who did not have confidence in the 2020 election have perfect confidence in the 2024 election's integrity.
And
Go ahead, Tony.
Dan, just a follow-up. Are there areas in election administration looking ahead to 2026 and 2028 that you think further improvements need to be made? Or do you think that the improvements have been uniform such that we're in a much stronger position heading into those elections than we were 10 or as you said, certainly as long ago as Bush v. Gore?
Yeah, I think we're in a reasonably good position. There are certainly changes that I would like to see made, that virtually everyone I know would like to see made. Let me first say, there are some changes that have been made over the past several years, most notably the Electoral Count Reform Act, which I think reduced the possibility of manipulation of the Electoral College process. Don't eliminate it entirely, but certainly make that system better than it was before. In terms of changes that should be made, let me point out a couple that, quite frankly, aren't likely to happen anytime soon, but I think of as really big issues, outstanding issues that we really ought to address. One of them is who runs our elections, and this has been a long-standing problem going back to 2000, at least in terms of public awareness of it, with Katherine Harris, the Secretary of State of Florida, in 2000, who was a strong supporter of then Governor George W. Bush and his campaign, perceived as exercising her duties in a way that benefited him. We've seen similar allocations on the Republican side from time to time with respect to Democratic officials. I mean, the fundamental problem is that in most states, we have a partisan elected official who is the chief election authority of the state. Usually it's the Secretary of State. And let me be clear what I mean in saying partisan. I'm not alleging that they're all biased and exercising their responsibilities in a biased way. What I mean by that is that they are partisan in the sense that they were elected to office as representatives of their party, and therefore have a conflict of interest between their obligation to discharge their duties even-handedly on the one hand, and their desire to serve their party and its candidates on the other. There's an inherent conflict of interest built into that role. And even states that have appointed chief election officials have that problem. We here in Wisconsin have, I think, a better system than most, where we've got what's effectively a bipartisan board responsible for overseeing elections with an executive that is chosen by that board. But partisanship in election administration, especially at the state level, it is one of those big unresolved or unfixed problems of the last quarter century. And the other really big problem, I think, is what I mentioned earlier, the Purcell Doctrine, sometimes called a principle. It's nice alliteration, but it's not a principle, so please stop calling it that. This has become an almost absolute bar against federal courts issuing injunctions shortly before an election. The fundamental problem with that is that sometimes things happen close to election that threaten voters' rights. And the Purcell Doctrine makes it practically impossible to remedy that, at least to remedy it in a federal court. Now, there's a kernel of wisdom in this. Sometimes it can be disruptive if a federal court issues an injunction right before an election, but sometimes it's a lot more disruptive if a federal court fails to protect voters' rights before the election because people will be disenfranchised or there will be, really chaotic situations at the polls, as we've sometimes seen. So fixing the Purcell Doctrine would be, if we had a dream Congress, that would be on my list of things that we would really want to clean up. And one of the big problems with Purcell is that if you can't resolve disputes before an election because a court says, or the Supreme Court says, it's too late, what's your choice? Well, you're left cleaning up the mess afterwards. And that's more or less what happened in North Carolina with its Supreme Court race that stretched on for just about 6 months after Election Day.
And Dan, doesn't Purcell incentivize legislatures to make election law changes late in the day so that they escape judicial review?
That's right. It incentivizes not only legislatures to do things late in the day, but election officials. I said earlier, I think most of them try to do their jobs in a fair way, but not everyone, and certainly not always. And, in Ohio, we've seen a lot of that over the years. I mean, sometimes perhaps understandably, but sometimes you scratch your head where either the Secretary of State or some other election official will announce a change in policy or practice pretty close to election. When I was there, and I left Ohio 5 years ago, but we'd see this flurry of directives and advisories and other orders from the Secretary of State before every election. Some of them may be pretty uncontroversial, but occasionally they're ones that are really problematic. If we've been in this game for long enough, I'm sure Steve remembers this. You remember when Secretary of State Blackwell was in office, the 80-pound paperweight directive that he would only receive, I think it was absentee ballot applications if they were printed on 80-pound, that's that heavier paperweight, right? And so that got reversed in court. But if Purcell had been the law back then, well, that order might have stood, or at least you wouldn't have been able to go to federal court to get it fixed. So I think we should stop calling it the Purcell principle and call it what it really is, the Purcell problem.
Now, as you think about Purcell and its impact, it has evolved over time, and it is entirely a judicially created doctrine, and it's now about 2 decades old, I think, roughly, but it seems to be showing up more and more often. But you made reference to the possibility that a more functional Congress might do something about it. Given that it's judicially created, though, what do you think about the promise of some judicial readjustment of what Purcell has led to?
I would say if we had a different Supreme Court, that might be a possibility. But of course, Congresses are easier to change than Supreme Courts. And the current Supreme Court, regrettably, seems to really like Purcell, although some have pointed out that they don't always seem to apply it in the most neutral way. They're much more likely to apply it, it seems, in a way that benefits Republicans and conservative candidates than Democrats and liberals. So I don't think it could be changed by the Supreme Court. It could be softened by the Supreme Court. I'm not really holding out much hope of that anytime soon. But I think, Congress, which retains the power to regulate judicial processes and often exercises that power. I teach civil procedure in addition to election law, could certainly step in if it were inclined to do so.
And what's your sense of whether one of the reasons, or maybe a main reason, that often in its application, the Purcell doctrine seems to disadvantage Democratic candidates or left-leaning voters?
Yeah.
Is that because the issues
Yeah.
are distinct? The kinds of issues, the kinds of claims that would make an impact that would favor Democratic-leaning voters are of a category that the courts have been less likely to think deserve last-minute adjustment.
Yeah, well, that's a really interesting question, and it actually gets into something that may be changing in our elections and politics. So, traditionally, and this goes back not only to 2000 and the Help America Vote Act of 2002 and all the subsequent debates we've had over voter identification and the like, but traditionally, Democrats and aligned groups have favored access, right? Making it easier to vote. Republicans have tended to emphasize integrity or security and favored measures to prevent voting fraud, rare though that is. And I think it has generally been the case that more liberal voting rules generally favor Democrats, right? The easier it is to vote, um, the more likely it is that Democratic-leaning voters will be able to vote and have their votes counted. But that's really not only changing, I think it's actually changed, right? If you look at the demographics of the parties, and I see Tony nodding, you probably know a lot more than I do, they've kind of flipped over the last 30 years or so, right? The Democratic Party used to be the party of the working class. It used to be the party consisting primarily of non-college educated, blue collar, quote unquote, voters. But now the Democratic Party is predominantly the party of college educated voters. And the Republican Party is in some ways what the Democratic Party used to be, not necessarily in terms of its policy positions, but in terms of its demographics, right? Non-college educated voters, particularly white voters, but increasingly voters of color, and fascinatingly, I should say, voters of color have been, or it seems to be, are trending Republican. So, while we tend to think of easier access to the ballot as benefiting Democrats and tighter restrictions as benefiting Republicans, that's not necessarily going to be the case moving forward. The easier it is to vote and the more people are voting, well, that might actually help Republicans in the future and perhaps even right now. I saw at least one study that, if everyone had voted, Trump would have won by a lot more than he actually won by. So I think this may be a situation in which the politics just really haven't caught up to the political reality.
Yeah, Dan, I think that's exactly right. Obviously, we're in the early stages of this class realignment, but it certainly appears from a historical perspective that this is the biggest class realignment of our politics since the 1930s, which also had lots of paradoxes. And in the 1930s, African Americans voted for a Democratic president for the first time ever. African Americans voted overwhelmingly Republican from Abraham Lincoln in 1860 through Herbert Hoover in 1932. It was the 36th election, FDR's reelection, that saw Democrats finally win a majority, which is very paradoxical because at the same time, central to FDR's coalition was the white supremacist Southern Democratic Party. So in some ways, these paradoxes we see today are seen in history as well. But that then raises a question where I think it's really a perfect segue to your compelling our new article in Alabama Law Review on racist voting. So maybe we could just begin with the definition. What is racist voting?
Yeah, great. By racist voting, what I mean is racially discriminatory intent. Voters who cast their votes motivated by racial discrimination, whether it's the intent to vote against a candidate because of their race, or alternatively, the desire to support a candidate because they think it will be harmful to people of some race, right? So, racially discriminatory intent, right? The Supreme Court has long held, going back to a decision now almost 50 years old, Washington versus Davis, that came out from the US Supreme Court in 1976, that in order to show race discrimination that violates the United States Constitution, and specifically the 14th Amendment, now the 15th Amendment as well, you've got to show that voters acted with that, you've got to show that government officials acted with that discriminatory intent. It's not enough that a certain decision or practice has discriminatory effects, right? The question is whether when voters are casting their ballots, they are engaged in some sort of state action such that racist voting might either individually or collectively violate the Constitution. Are they, in other words, state actors? I have a both yes and no answer to that question. On the one hand, I think that as individuals, we have a right to cast our ballots, at least functionally, the way we like, for whatever reason we like. As it turns out, historically, this wasn't always so clear, but I think the combination of the secret ballot combined with protection against compelled disclosure means that we as voters effectively have the freedom to cast our votes as we wish for whatever reasons we wish. And by the way, let me also say, I think that's a good thing. I don't want somebody looking over my shoulder telling me how I can vote. The problem is, when we're casting our votes, we're not just acting as individuals. Our votes get collected and used by the government to decide who will represent us in office. There is, in other words, in that collective process, state action. And so my argument is that while individuals have the freedom to cast their votes for whatever reasons they wish, including racist ones, when election results are decided by racist voting, when there's sufficient racist voting, in other words, to make a difference in who gets elected to office and who loses, that would constitute a constitutional violation, a violation of the 14th and 15th Amendments. Now, as a practical matter, I don't think it's one, this is a violation that courts can remedy. And, we've gotten so used to thinking about courts as the way that we remedy violations of constitutional rights. But if you go back to the history of the 14th and especially the 15th Amendment, Travis Crum, professor at WashU St. Louis, has some great recent scholarship on this that I really read and learned a lot from in the course of writing this article. That's not how the framers of the 14th and 15th Amendments thought about constitutional rights. They really thought of Congress as the primary protector of constitutional rights, not the courts. So my argument here is not that courts should overturn election results where they decide they were influenced by racist voting. It is instead that Congress should be understood to have the power to remedy racist voting where it's sufficiently prevalent to affect election results. And moreover, that Congress has already actually done so, that Section 2 of the Voting Rights Act should be understood as a remedy for collective racist voting.
But in thinking about the issue in those terms, notwithstanding what is in the Voting Rights Act now, are you calling for some congressional clarification, amendment, recalibration? Do you think there's... Yeah, sorry, go ahead.
I'm actually not, at least not in this piece. We might imagine there could be laws that could better protect us against collective racist voting. But that's actually not the argument that I'm making in this piece. The argument that I'm really making in this piece is one that's designed to shore up the constitutionality of Section 2 of the Voting Rights Act, which is very much a live issue after the decision a couple of years ago in a case out of Alabama, Allen versus Milligan, where several of the justices seem to have constitutional concerns about Section 2 of the Voting Rights Act. And the traditional constitutional justification for why Congress has the power to protect against racial vote dilution is that it's protecting against intentional discrimination, intentional race discrimination by legislative bodies. Well, that may sometimes justify applications of Section 2 of the Voting Rights Act, but I actually think that it's better understood, this landmark statute, as protecting against collective racist voting that would prevent people of color from electing their preferred candidates because of racist voting by the white majority. We might also imagine situations in which it's the reverse, and given that equal protection law is symmetrical in the sense that intentional discrimination is prohibited, whether it's against whites, blacks, Latinos, Asians, Native Americans, or any other group. What's good for the goose has to be good for the gander. So racist voting in favor of, say, Asian Americans has to be just as unconstitutional as racist voting against white Americans or black Americans, for example. But to your question, Steve, I'm not really calling for new legislation. I'm really making an argument for why the legislation we've got is constitutional.
Yeah, that's a really interesting way of kind of rethinking the Voting Rights Act, I think. And there's a clear interdependence between what it is that more historically courts have looked at in terms of the way in which state legislatures or other government actors have behaved that might deprive a racial minority group of the ability to elect representatives of their choice. But of course, all of those cases are assessing what's happening on the ground in light of government action in the face of the way in which voters behave, right?
Right.
The whole notion of block voting, right? Which is such a central overlay in the way in which the questions have been addressed. So I think this is a nice contribution in thinking about what it is that the Voting Rights Act can help address.
Yeah, and I'm actually answering a question in this piece that was posed by Justice Thomas, which I actually think, despite my disagreements on many things, including the Voting Rights Act with him, is a reasonable question. What is the constitutional wrong that Section 2 of the Voting Rights Act and its prohibition on, say, redistricting plans that have racially discriminatory results? What is the constitutional wrong that this statute is designed to guard against? The traditional answer to that question is intentional discrimination by legislative bodies that are, say, drawing district lines. And I don't think that's a wrong answer, but I actually think that Section 2's emphasis under Thornburg versus Jingles and 1982 decision from the Supreme Court and the line of cases that follows it, the emphasis on racial bloc voting or racial polarization is much better explained if we understand the statute as a remedy for racial discrimination by voters rather than racial discrimination by legislators. Because, yeah, racial polarization is not exactly the same as racist voting, but it's related, right? Racial polarization might indicate that people are casting their ballots for racially discriminatory or racist reasons.
Dan, at a time when the United States is, by so many measures, more diverse now than ever before, certainly than in 1868 or even 1965 with the Voting Rights Act, how should we understand racial bloc voting? What threshold should there be for determining racial polarization at a time when it's very easy to imagine scenarios now where the majority might really mean a white Latino majority block voting? The Pew Research Center study came out last week showed it looks like Trump almost won a majority of Latino voters nationwide, whereas Harris still won a super majority of African American voters. What is the threshold in an era where we're looking at multiracial voting coalitions in both parties?
Yeah, it's a fantastic question, Tony. And you're a political scientist, not me, so I'm not sure I have a great answer. You could probably provide a much better answer to that than me. How racially polarized does voting have to be in order for it to violate the Voting Rights Act? And I'm not going to really answer your question. I'm going to dodge it and answer a different question, which is, what exactly? There's this debate that actually goes back. This is really for the election law nerds here. It really goes back to 1982 and the difference in the opinions is between, the mostly majority, but for part of it, plurality opinion by Justice Brennan, Justice White, who wrote a brief concurring opinion, and Justice O'Connor, who wrote a concurring opinion, but one that reads more like a dissent. What do you have to show in order to prove racial polarization? Do you have to show just patterns, correlations between race and candidate preferences? How strong does the correlation has to be as a subsidiary question? Or do you have to actually show that it was because of race that voters voted the way they did? If it's the latter, then racial polarization becomes very similar to what I call racist voting. But and there's a split in the case law that persists to this day over what exactly you have to show. I tend to be in the camp that you've got to show a correlation, not necessarily causation, which political scientists always tell me is always difficult, if not impossible, to prove. But at least some courts have held that out as the standard in Section 2 litigation.
That same set of issues resonates differently too when you think about the goose and gander dimension of this, I think. I mean, in response to Tony's initial question on the subject about just what your definition of racist voting is, I think I heard you describe it in terms of voting that is in some fashion or other expressing some degree of hostility towards a racial group. But of course, another way of broadening the definition is to think of it as voting that is motivated out of a kind of overwhelming sympathy for or enthusiasm for a particular candidate because of that candidate's race.
Yeah.
And those dimensions of this seem to me to make it really difficult even to be able to figure out a correlation.
Right.
Given the changing demographics Tony made reference to.
Yeah, and it's a fascinating point. And right, like if we think about it not only as voting that's motivated by hostility towards a particular group, but by favoritism towards a particular group, there might well be a lot of racist voting out there, right? I mean, and there probably is racist voting in almost every election. Certainly, in elections that feature opposite race candidates, where some people may vote for a candidate because they're white, some people may vote for a candidate because they're Latino, and so on. Um, but even in, same race elections, right? You could imagine somebody voting for a candidate because they're going to support policies that help your racial group and you strongly identify with that racial or ethnic group. That would be racist voting under my definition. I do think, and I spent a lot of time in this a fair amount of time in the article talking about it. As a practical matter, proving that in any particular election is going to be impossible. The standard for showing intentional discrimination is a pretty high one. I don't think you're going to be able to meet that burden of proof. Certainly, in the length of time that it would take to actually litigate it and get a result before somebody's term ends. So, the argument I'm making, I'll lay my cards on the table here, is really one that gives more power to Congress. And I'm okay with that. I want Congress and not the courts to have the power to define remedies for racial discrimination, whether it's by legislators or by voters. I mean, I think that is actually, I'm not really an originalist, but if you are an originalist, that is much more in keeping with the spirit of the 14th and 15th Amendments than the system we have right now, where the Supreme Court has set itself up as not only the articulator of what constitutional rights are, but the entity that decides how they should be implemented and enforced.
And Dan, the whole role of the Supreme Court in our elections has always given rise to questions about the proper place of the Supreme Court in a democratic order.
Yeah.
And we're certainly living at a time where there are so many challenges to our democracy.
Yeah.
How do you assess the state of American democracy in the year 2025?
That's a big question.
It is.
I guess I have an answer, which is it's in pretty bad shape, right? Like I think it's we've got some really big problems, starting with just the hostility that exists towards people of the opposite party, the inability of people in Congress to work together. And, the Congress appears to be poised. We don't know exactly what's going to happen as we record this podcast, but poised to enact this major bill that will, affect revenue and, at least according to some arguments, create trillions of dollars in budget deficits without any bipartisanship, right? There's just no working across the aisle and very little incentive to work across the aisle. And we've seen in this increase in political violence, which I think is pretty clearly related to the polarization, the effective polarization that we see, the hostility that exists towards people of the opposite party. We're living in really scary times for democracy. So I think the state of our democracy is really bad. I guess the big point I want to make, tying it back to our earlier discussion, is that while elections sometimes become the focal point for that anger, I don't actually think election administration is the problem, right? The problems with our democracy have very little to do with how we run our elections. And you can certainly make arguments that our system of campaign finance, our systems of redistricting and gerrymandering bear part of the responsibility. But the problem isn't really voter ID laws. Or even partisan election administration. If anything, those are symptoms of the problems rather than the cause of the really serious problems that our democracy is facing right now.
Also, you mentioned, a couple of things people often like to complain about, including things like redistricting or campaign finance law. I can put another one out there, which would be partisan primaries, which might, in the view of many, I think I'd include myself in that category, be a bigger problem today than campaign finance or redistricting process. It's a structural feature, but I also want to just know whether you think the problem really is something outside of the entire electoral structure. And is it just inherently the case that democracy reaches a point that we've reached now, or is it social media, or what do you see it as?
Yeah. I do think the problems in our democracy are largely exogenous to our election system. I think I do think, however, our campaign finance system has partly contributed to them. And this really gets to the answer to your question. Well, if it's not our election system that's causing these big problems, including hyperpolarization and attendant legislative dysfunction, what is it? At bottom, I think it's economic inequality. I think it is rising economic inequality and even more to the point, the lack of social mobility that fuels distrust of government, that people across the political spectrum, although we tend to see it now more often on the right, but I do think it's to some extent across the political spectrum, are just really dissatisfied. They feel like the system's working really well for elites, maybe for people like us, if we're going to be honest, certainly corporate elites, but not working very well for them. And there are different places where the blame gets placed. But, I started to come to this realization, Steve, probably around the time of the 2016 election, where you'll remember, the four candidates still standing after first part of the primary season was over, were Donald Trump, Ted Cruz on the Republican side, Hillary Clinton, and Bernie Sanders on the Democratic side. All three of those four candidates were really anti-system candidates in different ways, to be sure. But you look at the back and forth that we've had, where the incumbent party has lost in the last, let's count, right? 2016, 2020, 24 elections, right? People are massively dissatisfied with our political system. And while there's no single cause, I think more than anything else, it is economic inequality and the lack of social mobility. And, Tony's probably looked at the research more carefully than me, but I think there's a fair amount of evidence that there's a correlation, not just going back over the past 50 years in which both have increased, between political polarization and economic inequality, and going back, over a century now, that I don't, last time I looked at the political science literature, I didn't see a great explanation in it, but that's kind of mine. I don't, certainly there's no one factor that explains democratic dysfunction, but that's at the top of my list.
But does that?
I'd love to hear Tony's take.
Oh, I was just going to say, I think that's exactly right. I certainly think it, when we think of the 1930s, the historical precedent, so many ways for the political realignment we're experiencing today, that's a case in point. It was the middle of the Great Depression. And also, if we see what's happening beyond the United States, we're also seeing populism and polarization in country systems. We're seeing it in every corner of the globe. And globalization, which was a term I certainly embraced for decades, it now has become a synonym, it seems like, in much of the world for income inequality. So I certainly think the evidence overwhelmingly supports your points.
Yeah.
So does that suggest, though, at least an argument could be made that our campaign finance laws are more responsible for things? If we think about the last 50 years, since we essentially have said that campaign finance law cannot restrict the role that wealth plays in affecting public policy. And if that then leads to greater income inequality, that's just the necessary result.
I think it's a part of it. I do think it certainly has something to do with the ability of some groups, based on their wealth, to exercise greater political power than others to get what they want. We're certainly seeing that in the legislation that's moving through Congress at the moment, in my opinion. But I think it only can explain so much, in part for the reason that Tony just explained. This is not just a U.S. phenomenon, right? And a lot of countries, well, virtually every other country has more restrictions on the flow of political money than the United States too. And these other countries are feeling some of the same things and seeing some of the same things than we are. Like, dissatisfaction with the political status quo is by no means confined to the United States. But you have seen rising economic inequality in other countries too. Maybe not quite to the same degree that we have here in the United States, at least in many countries. So I think our campaign finance system can partly explain the degree of polarization and dysfunction here, but I think it's a bigger problem. Even if we had my or your ideal campaign finance system, I still think we'd have massive economic inequality and not nearly as much social mobility as we in the United States and most other democracies aspire to, or at least say we want.
Dan,
Or maybe as we need in order to maintain
A
real
healthy
democratic
democracy.
health.
Yeah, I think that's right.
Dan, you're the dean of a law school at a famous land-grant university. You know, public universities, flagship public universities, played such a central role in promoting social upward mobility going back to the 19th century. Why do you think survey after survey in the last decade has shown a decline in public confidence in higher education, not just public universities, but private as well? But it's hitting both. What is driving that?
Oh God, it's such a great question, Tony. Thank you for asking it. And it's something I've been thinking a lot about. I think a lot of it has to do with access or lack of access. That you know, certainly private institutions, but even at public ones, who's getting in, who can afford to pay, right? Our tuitions have gone up. I mean, there are explanations for that. The amount of support we get from the state has certainly declined over the years in real dollar terms as a percentage of our overall budget. Higher education seems, and for a lot of people, quite often is out of reach. And I think we who are leaders in higher education need to take some ownership for this. I don't think we've done a good enough job in colleges and universities and in society more generally in ensuring equal access to higher education, particularly for people of lesser economic means. I was actually looking at some statistics just recently about who gets in, who goes to colleges and universities, and how does where you're coming from affect your likelihood of being able to get a college degree. Well, one study I found that if both your parents are college graduates, you've got an 84% chance of earning a college degree. If neither of your parents are college graduates, either of you want to guess?
20%.
That's what I guess.
Right on. That's exactly right. So like where you're coming from influences where you wind up. So I just think we have a lot of work to do in providing access, and certainly a lot of it starts at the primary and secondary education level. I don't want to stand here and say we who are running or administering colleges and universities are entirely responsible, but I think we do have to take some responsibility to provide greater access.
It strikes me, Dan, that polarization, especially residential polarization that really sort of tracks now partisan polarization, it's playing a role in this.
Yeah,
because
absolutely.
If college educated families are congregating in certain suburbs or certain neighborhoods, then their schools have far more resources and just sort of the cultural support for students, increased likelihood they will go. And then you end up with school districts with very few parents who are college educated. So we see this play out in partisan ways, but it has an implication for higher education as well, it seems to me.
Well, and you can certainly see that in the political support for the massive cuts to higher education that are happening right now that are affecting all of our budgets, right? Like I can certainly understand if you're living in a rural community, you look at all these federal dollars going to Harvard or even to Ohio State or UW-Madison. It's like, why should my taxpayer dollars go to those schools? My kids aren't likely to get into those schools, and even if they do, I don't know if we're going to be able to afford tuition. So, I just think we may disagree with that perspective, but there are reasons why trust in educational institutions um, is way down. And I just think we have to take some responsibility as educational leaders for fixing the problem.
Well, I'd love to continue pursuing all of these themes, all of these topics. This has been really rich, and it's great to have you join us for this, Dan. And we certainly miss you at the election law program here. And we also certainly hope the best for you and your role as an administrator in the higher ed community today.
Thank you so much. Well, it's really been a joy, Tony and Steve. And to the extent it was rich, it's because of the great questions that you all posed and also you both lending your insights. So I really appreciate your giving me some time and wish you all back in Ohio the very best.
Well, thank you, Dan. Thanks,
Thank
Tony.
you so much.
Until our next episode, be well, everyone.
Take care.
Bye-bye.
Bye-bye.